But let's talk about what happened in Lower Manhattan yesterday in the courtroom. The testimony, at times, we were saying earlier, was perhaps a little cringy when she was describing what happened in that hotel room, she says, in Lake Tahoe in 2006. Some of the comments that then, not President, but just Donald Trump was talking about his wife and his daughter, making comparisons to Stormy Daniels. What did you make, though, of her effectiveness as a prosecution witness?
So I thought she was effective. I thought the cringe was kind of the point. This was the story that Donald Trump did not want America to hear. This is why he was willing to pay the money to her. A guy who we've heard is very frugal, was willing to make sure this payment was made so that America didn't hear about him showing up, in his Hugh Hefner satin pajamas, that he didn't sleep in the same bed as his wife, and that there was a woman he wanted to sleep with who he was saying reminded him of his daughter, right? Like, ick. I mean, so you had all of these things that portrayed Donald Trump as really this kind of lame, desperate, creepy old man. And that is a story he wouldn't have wanted to get out. I mean, if that had gotten out, it would have been make America gag again, because that's how it felt in the jury, in the overflow room. There were people who were having visceral reactions to what she was saying. So I think, again, it just drove home the prosecution's point. This was the story he did not want to get out, and that's why he made the payment. And
so, Joyce, what we heard from the defense yesterday, effectively, is that this might be interesting, it's tawdry, it's salation, but it's not connected to the alleged crime. How do you draw the line between what happened allegedly in that hotel room in Lake Tahoe in 2006 and the crime the prosecution is alleging here?
Right, and that's exactly the issue that got teed up in the motion for mistrial yesterday. So Christie is absolutely correct when she says that it's legitimate for the prosecution to present this testimony. It explains to the jury what it was that Donald Trump was trying to prevent, what he spent his $130,000 to keep out of the public domain. And the issue for appeal is whether or not that was unduly prejudicial to Donald Trump in the sense that the judge was wrong when he denied the mistrial. But there's a midway strategy here that the judge will use to prevent there being any error that taints a verdict if Donald Trump is convicted in the case. The judge has said he will give the jury a limiting instruction. And our colleague Danny Sabalas was on in the first hour suggesting that you can't unring the bell once a jury hears testimony like this. But that's not really the case. And the law says that where the judge gives a limiting instruction, telling the jury, for instance, in this case, it might be something like, you can't consider this evidence for the truth of the matter. You're not called upon to decide whether, for instance, this sex was consensual or distasteful, or whether Stormy Daniels was threatened in a parking lot. You can only use this evidence to determine what the story that Stormy Daniels would have told was that Donald Trump and his campaign wanted to keep out of the public domain. So a limiting instruction like that will cure any possible error and permit a verdict to be affirmed on appeal if there is one.